Andrew Grimm parked his car on a street in Portland. He paid for an hour and 19 minutes using a phone application, and then he never paid again. And rather than driving off, he left his car in the same spot for about a week. Unsurprisingly, for the first 5 days, a parking enforcement officer was driving by and leaving a bunch of tickets under the windshield wiper. As those tickets accumulated, after 5 days, the officer left a red warning notice saying that this vehicle will be towed in 2 days. Again, the vehicle was never moved. 2 days later, the officer left some more tickets and then attached a notice saying that this vehicle will be towed today. A few hours later, a tow company went by and picked up the vehicle. It then cost Andrew over $500 to pick up his car from the tow yard. He then sues the city and argues that the vehicle was towed in violation of his 14th Amendment right, specifically the Due Process Clause. He says that he never received proper notice that his vehicle would be towed. And he also argues that the city knew that he was not getting that notice because nobody was picking up those tickets. Now, this case very much reminded me of a case that I handled a few years ago that dealt with a $30 million dispute between a bank and my client. And sometimes even the biggest cases boil down to something very simple, whether somebody gets notice about a lawsuit. Here specifically, Andrew argues that he didn't get notice that his vehicle would be towed. So today we're going to discuss something that will probably involve most of you in your life, that is specifically getting a ticket for parking, and worse, getting your vehicle towed. Before we go on, I want to thank you for watching me here on YouTube. Welcome to Lost Hash channel. If you're new here, hit that subscribe button. If you're a returning viewer, please share my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to losthash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lost Ash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Ash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Ash YouTube page. That's LAWSTACHE.
Happy New Year to all of you. We begin 2025 with the first substantive case from the Ninth Circuit, Andrew Grimm versus City of Portland. Now, if you're from Portland or if you've ever been there, you know that once you park on the street, you have to utilize what's called Parking Kitty, which is the application on your phone to pay for that parking. Parking Kitty is also associated with an entity called Passport. In order to download this app, you have to provide your name, credit card information, address, phone number, and optional, your email address. Andrew Grimm has done all of that. At some point, he parked on the street, and utilizing this app, he paid for an hour and 19 minutes. Now, he received notification, sort of a receipt from Parking Kitty, saying that he parked at this particular location and how much he paid for it. Now, something to note. The information that he provides to Parking Kitty is not necessarily shared with the city of Portland. Now, he paid for that hour and 19 minutes, and then he sort of forgot about it. He left his car there for about 5 days. During that time, unsurprisingly, parking enforcement officer was driving by and leaving a bunch of traffic citations under the windshield wiper. On the 5th day, the officer left the citations and he added another red notice that had the following message. The warning slip displayed the word warning in large print on one side and included on the other side the following sentence. Your vehicle will be subject to tow/citation if it is not moved. The officer then circled the word tow/citation and underlined the word tow. 7 days after Andrew Grimm first parked his vehicle on the street, it was towed. And then the city mailed a notice to Andrew on how to retrieve the vehicle. Now, they mailed this notice to the address associated with the car registration. 2 more days passed, and then Andrew finally went to the tow yard to retrieve his vehicle. He had to pay over $500 to get it back. He then sued the city and said that his 14th Amendment rights were violated, specifically the Due Process Clause, because he never received notice about the vehicle towage. So first, let's take a look at the 14th Amendment and what it says. An elementary and fundamental requirement of due process in any proceeding which is to be accorded finality is notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. In determining what notice is appropriate under the Mullane standard, we must balance the interest of the state and the individual interests sought to be protected by the 14th Amendment. A plaintiff need not receive actual notice under this standard. Andrew Grimm argues that the red notice that was attached to his car 2 days prior to it being towed was insufficient when the city knew of his address from the registration. They also knew potentially some other information like his phone number, email address through the Kitty parking application. Now, we know that the Kitty application is not necessarily sharing information with the city, but again, the city might have been able to gather that information and send notice to Andrew Grimm. Now, the Ninth Circuit completely rejects this notion and instead says this: an individual with an interest in preserving uninterrupted access to his car would revisit the car after his parking session ended or his meter ran, and seeing such a notice would either move the vehicle or pay for additional parking time. I think the court reached a rather unremarkable conclusion. Most of us will agree that leaving a red notice on the vehicle 2 days prior to it being towed is sufficient under the 14th Amendment. But then the court spends only a few pages discussing what I think is a much better argument from Mr. Grimm. He argues that, generally speaking, under the 14th Amendment, when the government sends a constitutionally adequate notice to the recipient, but nevertheless knows that that normally effective notice was not received by the recipient. For example, when the government sends a certified mail to an address, but instead that mail bounces back, well, the government knows that that notice was not adequate and was not effective in this particular situation. And so the Supreme Court said that if that happens, the government must try harder. They must go into more effort in providing notice to the recipient prior to seizing that person's property. So that's what we're dealing with here. And instead, the court answers it in a few lines. Here's what they say. Viewing the evidence in light most favorable to Grimm, we cannot draw a reasonable inference that the city ever became aware that its attempt to notify him of the impeding tow had failed. My answer to that is, really? Do you think, as a reasonable person, when you see a vehicle on the street that's getting dirtier and dirtier and has been there now for 5 days with a bunch of tickets under the windshield wiper, as a reasonable person, do you think that the person who owns the vehicle is coming by, checking the notices, looking at the tickets, and then just ignoring them and putting them back? Or do you think that that person is out on vacation, out of town, or maybe got sick and is not paying attention to the vehicle? I think most of us will agree that if that's the situation, it is more likely that the person is not paying attention to the vehicle. And thus it means he's not getting notice. So I don't agree with the court. I don't think Mr. Grimm is lying to us when he says that he never received notice. And then the city should have known that he's not receiving that notice because they're seeing all of those citations being accumulated on the windshield without being touched. Nevertheless, the court says that the 14th Amendment was not violated, and so Mr. Grimm loses his case. If you learned something here on the Lost Ash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Welcome to 2025. I hope you will share one more year with me, or as many years as I do this on YouTube. Thanks again to all of you for the viewership, and I'll see you next Wednesday for another deep dive on another case. Thanks for watching.